This meeting of the Senate Judiciary Committee will come to order. We have 6 nominees and 4 bills on today's agenda. The nominees have been listed for the first time and will be held over at the request of the minority. They are Myrna Perez, nominated to the Second Circuit; Gia Cobb, nominated to the D.C. District; Sarah Merriam, nominated to the District of Connecticut; Florence Pan, nominated to the D.C. District Court; Karen Williams, nominated to the District of New Jersey; and Matthew Olson, nominated to be Assistant Attorney General for the Department of Justice's National Security Division. I look forward to voting on those nominations next week. So we have 4 bipartisan bills on the agenda today, ready for consideration. These bills help address the high prices of prescription drugs in meaningful ways. We all know, since part of our business is trying to make sure we understand what's on the mind of American families, this is one of the most important issues to them, the cost of prescription drugs. 2 weeks ago, the Subcommittee on Antitrust held an important hearing on this subject. The hearing showed there is a bipartisan consensus that Congress must address soaring cost of prescription drugs. And we're way past time for the Senate Judiciary Committee to do its part to meet this challenge and hold drug companies accountable for conduct that is anti-competitive or hurts American families. As we heard at this earlier hearing, nearly 40% of patients in America struggle to pay for medication. Why? In part because there are fundamental flaws in our drug pricing system that the drug companies capitalize on. What is the world's best-selling drug? Well, when I say the name, you'll say, of course, it must be. Humira had $16 billion in sales in the United States in 2019. AbbVie, out of Illinois, which makes Humira, has obtained a stack of 130 patents on this single drug. 130 patents on Humira, with 90% of the patents filed after the FDA approval of the drug. That's not pro-competition. Now, let me tell you the story of insulin, because it's so prevalent and so important. First discovered 100 years ago, when its patent sold for $1. Fast forward to the year 2000. Sanofi's Lantus insulin was approved with a price of $35. Year 2000, $35. Well, since that time, Sanofi has obtained 45 follow-on patents to block competition, allowing a price for a vial of insulin to be raised 25 different times to more than $350 today. These abuses are outrageous, and it's time that Congress wakes up to it. I will speak about each of the bills as we consider them, but I want to thank all the sponsors for their efforts to help stem out-of-control drug prices. Today's agenda shows that this committee will continue our bipartisan work to pass legislation addressing important issues. With that, I turn to the ranking member, Senator Grassley.
I want to give a short remarks about each of the bills, and I don't think I'll need to speak during our debate on those bills. The Prescription Pricing for People's Act would require the FTC to study the pharmacy benefit manager industry and provide recommendations to address abusive PBM behavior. The text of this bill is the same language contained in the Grassley-Cantwell bill that was passed out of Judiciary Committee in the last Congress. Just for everybody's memory, even though the bill didn't come up last year, Wyden and I worked on a prescription drug bill that had a lot of transparency for the PBM industry that we think would have reduced a lot of the game playing that goes on between health insurance companies, PBMs, pharmaceuticals, and where does the consumer benefit. This bill is doesn't have any reforms in it, but just in case we don't do something on the pharmaceutical industry like we didn't do last time, this bill will get us to a point where we can at least deal just with the PBMs. I'd just like to note that earlier this year, I released a bipartisan report detailing the abusive business practices of PBMs, particularly as related to the insulin therapeutic class. Specifically, my report details the practice of requiring rebates and other fees to secure preferred formulary placement, and how this caused the list price of insulin to soar to astronomical heights over the past 20 years, hurting patients and payers in the process. This report underlines the importance of the bill that I just described to you. And of course, the need for the FTC then to conduct a thorough review of the PBM industry. The next bill, 1425, called Stalling Act, would help address abuse of FDA's citizen petition process, where entities file sham petitions to stop or delay the approval of generics that compete with brand drugs. The text of this bill is the same language contained in Klobuchar-Grassley bill that passed out of the Judiciary Committee in the last Congress, and it passed without objection. S 1428, Preserve Access to Affordable Generics and Biosimilar Acts, would limit anti-competitive pay for delay deals entered into by brand and generic drug companies that prevent or delay the introduction of affordable generic drugs or biosimilars to the market. Several versions of this bill have been considered in multiple Congresses. The current Klobuchar-Grassley bill is a companion bill to the House Judiciary Pay for Delay bill that they marked up in the last Congress. Senator Klobuchar and I have a substitute amendment that will offer to make changes requested by stakeholders and our fellow senators on both sides of the aisle, striking the retroactivity provision and adding language to exclude pro-competition agreements. Our changes in the substitute amendment mirror changes that were made during the House Judiciary Committee markup. Finally, S 1435, the Affordable Prescriptions for Patients Act, which would address evergreening and product hopping abuses by drug companies. A version of this Cornyn-Blumenthal bill passed out of the Judiciary Committee in the last Congress. So I hope we can move these bipartisan bills through the committee today and without a lot of controversy, get them passed into law so that we can stop drug companies' anti-competitive practices and ensure that lower-priced drugs are available to patients as soon as possible, if not sooner.
Thanks, Senator Grassley. The first bill we'll consider you've just referenced, S 1425, the Stop Stalling Act, sponsored by Senators Klobuchar, Grassley, co-sponsored by Senators Leahy and Blumenthal, and I ask consent that my name be added as a co-sponsor without objection. This bill would enable the Federal Trade Commission to deter abuse of the Food and Drug Administration's citizen petition process. Listen to the numbers. Studies have confirmed the prevalence of these activities, where pharmaceutical companies are trying to delay as long as possible the expiration of a patent protection and maintain their exclusive right to charge the highest prices. One finding that brand firms filed 92% of petitions between 2011 and 2015. The FDA granted an astonishingly low 8% of it. This bill would enable the Federal Trade Commission to deter abuse of the Food and Drug Administration's citizen petition process. The FDA allows citizens and companies to petition for delays, such as petitioning to delay approval for generic drug application. Brand name companies and their allies have been filing sham citizen petitions, raising dubious claims to stall the entry of generic competitors on the market. This results in brand name companies bilking millions of dollars per day from consumers with this anti-competitive activity. The Stop Stalling Act enables the FTC to seek civil penalties against those who file these sham petitions. I support this bill, and last Congress we passed it out by voice vote. I hope there's equally strong bipartisan vote today. Senator Klobuchar, do you wish to speak on the bill?
Yes. Well, I think you both described the bill well. I can't tell you how important it is right now to have some solution in place. I think every single year we see new ways that these companies, major companies, big companies, try to stop competition. And this is a narrowly tailored solution to the problem that will deter companies from engaging in this sham petitioning activity. while ensuring that the FDA can focus its attention on petitions filed in good faith that raise legitimate health and safety concerns. And I thank Senator Grassley for once again working with me on this bill, and I'd also like to thank Senators Leahy, Blumenthal, and Ernst, and you, Mr. Chairman, for the co-sponsorship of this bill. And I'd note that 90% of petitions between 2011 and 2015 were filed by branded pharmaceutical companies, not by concerned citizens or patient groups. And I think that pretty much says it all. It's a waste of FDA resources at a time when they should be using their resources to approve new drugs and help people who are sick get better.
Thank you. Senator Grassley is co-sponsor. Would you like to add anything at this point? No. Does any other senator seek recognition to speak or offer an amendment to the bill? If there are no amendments to be offered, we will vote on final passage. A clerk will, all those in favor of
say aye.
Reporting the bill, say aye.
Aye.
Those opposed? Wouldn't dare. The majority of members present, having voted in the affirmative, the ayes have it. The bill will be favorably reported to the floor. Next bill is S-1428, the Preserve Access to Affordable Generics and Biosimilars, sponsored again by Senators Klobuchar and Grassley, co-sponsored by myself, Senator Leahy, Blackburn, and many other senators who don't serve on the committee, such as Ernst, Collins, and Kramer. The bill would address anti-competitive pay-for-delay agreements. Those occur when a brand-name pharmaceutical drug company pays a competitor to keep a generic or biosimilar version of the branded drug off the market as part of a patent settlement. These sweetheart deals delay access to affordable, generic, and biosimilar drugs. That costs consumers and our government hundreds of millions of dollars in higher drug prices. The bill would presume that these deals are anti-competitive and prohibit them unless the parties can demonstrate that they're pro-competitive by outlining the benefits that they believe outweigh any negative effects. I'm proud to co-sponsor it. I urge my colleagues to support it. I understand there's a bipartisan manager's amendment, and without objection, the manager's amendment will be adopted. The lead sponsors of the bill, Senator Klobuchar and Senator Grassley, I'd ask each of you if you'd like to speak on the bill.
Sure. Thank you, and I know we're a lot going on here, including that a Minnesotan just won the all-around gold medal in the women's gymnastics, but I won't go on. I want to thank, again, you, Mr. Chair, and I'd like to thank Senator Grassley for co-leading this bill, as well as you, Mr. Chair, Senators Leahy and Blackburn, Senators Van Hollen, Ernst, Collins, and Kramer have also co-sponsored our bill. And this is something Senator Grassley and I have been working on, it feels like forever. The bill would prohibit the practice of anti-competitive pay-for-delay reverse payment settlement agreements in drug patent cases. These are settlements in which a branded pharmaceutical company shares its monopoly profits with potentially competing generic or biosimilar drug makers that agree to delay the introduction of a competing drug. Think about it. So you have a drug company, a generic's coming on the market, and so you're going to have some competition finally. The prices are going to go down, and they literally pay the competitor off. Competitor says, okay, I guess I'll make more money for a while this way, and then we have no competition, and it hurts consumers. This bill is our response to that conduct. The Preserve Access to Affordable Generics and Biosimilars Act strengthens the FTC's ability to challenge anti-competitive pay-for-delay agreements in court. It strikes the right balance. It deters drug companies from entering into anti-competitive settlement, but allows them to pursue agreements which do not harm competition. Pay-for-delay agreements are not necessary to settle patent disputes, and the bill narrowly targets the type of settlement agreements that raise serious competitive concerns, allowing pro-competitive settlements to proceed. I would note that it is sponsored by a broad range of groups, including Consumer Report, Patients for Affordable Drugs, AARP, Now, Public Citizens, Healthcare Alliance, American Academy of Dermatology, National Business Group on Health, and the National Retiree Legislative Network. Thank you very much. I urge my colleagues to support the bill.
I ask the lead co-sponsor, Senator Grassley, would you like to speak on the bill?
I already have.
Thank you, Senator. Does any other senator seek recognition to speak or offer an amendment? Senator Lee?
Thank you, Mr. Chairman. In the case of pay for delay, the current FTC enforcement system, which is based on the Supreme Court's ruling in the activist case, and the FTC's subsequent enforcement actions seem to be working. In activists, the Supreme Court held that pay for delay could in fact violate the antitrust laws if there were a large unjustified payment. That was sort of the buzz phrase, the catchphrase in that case. That is in exchange for delayed entry, and that the rule of reason should apply in any such case. The bill before us creates a presumption that a company has unlawfully compensated a generic or a biosimilar to delay bringing the product to market, also known as pay for delay, if certain basic criteria are met. My concern is that fundamentally changing the underlying legal standards of the FTC's current approach, as this bill appears to do, could risk upsetting the successful balance that we've struck between innovation and competition in the wake of the activist decision. That's why I've offered an amendment to change the evidentiary standard to require that it be required to rebut the presumption that the conduct is anti-competitive. So right now, as it's written, once the presumption is created, you can rebut the presumption only with the showing of clear and convincing evidence. So my amendment would change that from clear and convincing evidence to a preponderance of the evidence standard. Under the bill, once a company is presumed to have engaged in pay for delay, that company has to prove that the value given to the generic or biosimilar company is for other services, or the pro-competitive benefits outweigh the anti-competitive effects by clear and convincing evidence, which basically means that they have to prove that it's substantially more likely that the company did not engage in pay for delay than that they did. This is an incredibly high standard for civil liability, especially in the context of trying to overcome a rebuttable presumption. And it's also, I think, inconsistent with the standard used in the Stop Stalling Act for sham petitions. And so, again, my amendment would just lower the standard to a preponderance of the evidence, requiring parties to prove that that it's more likely than not that the company did not engage in pay for delay. It's a standard that's more commonly used in civil cases and would preserve this balance between innovation and competition. So, look, I like the bill, and I like what it tries to accomplish. I'm torn here as I've got the concern. If Senator Klobuchar, if you'll work with me on this one, I'd be happy to support you in getting this thing out of committee today, but I'd love to have you work with me on it as it approaches the floor. You okay with that?
I appreciate that, Senator Lee. I just, we have a disagreement on this, but I will work with you, and I also have appreciated all the work you've done on generics. So hopefully we can resolve this.
Okay.
Thank you.
Thank you. With that, I'll withdraw that amendment. Thanks.
I'd like to make one comment on this subject, and I'm glad it's working out the way it is. But it seems to me like since the Constitution was written and we want to promote innovation, and we're promoting innovation, and you got a patent, and the patent is for a number of years, what's the big deal after you run out of your patent? You want some sort of a scheme to continue to get the enrichment you did during the time that you have access to the patent. It just seems to me just common sense. The marketplace takes over after that.
Sounds like common sense to me too, Senator. Unfavorably reporting the bill, if there are no amendments, Senator Blumenthal. I
want to thank Senator Klobuchar and her co-sponsors and ask that I be added as a co-sponsor.
Without objection, that'll happen.
Let's have a voice.
Unfavorably reporting the bill, all those in favor say aye.
Aye.
All those opposed, no. The majority of members present having voted in the affirmative, the ayes have it. The bill will be favorably reported to the floor. The next bill is S-1388, the Prescription Pricing for the People Act of 2021. The sponsors are Senator Grassley and Cantwell, and co-sponsors Blumenthal, Tillis, and Blackburn. The bill directs the FTC to issue a report on pharmaceutical supply chain and whether pharmacy benefit managers, known as PBMs, are engaged in anti-competitive behavior that raises consumer cost. The bill would also direct the FTC to make policy recommendations to address anti-competitive PBM action. Last Congress, this bill was reported out of the committee by a voice vote. I support it. Ask unanimous consent to be added as co-sponsor without objection. Senator Grassley, do you have anything more to say?
I've said it all.
Anyone else like to say anything? Senator Coons. Senator Coons will be added as co-sponsor. Anyone else seeking recognition for an amendment or otherwise? If not, on favorably reporting the bill, all those in favor say aye.
Aye.
All those opposed, no. The majority of members present having voted in the affirmative, the ayes have it. The bill will be favorably reported to the floor.
Mr. Chairman, maybe add both bills as a co-sponsor.
Without objection, will be. You see where we're going next. The final bill on the agenda is S 1435, the Affordable Prescriptions for Patients Act of 2021, sponsored by Senator Cornyn, Blumenthal, co-sponsored by Ranking Member Grassley, Klobuchar, and myself. This legislation would empower the FTC to curtail drug product hopping. This is an anti-competitive practice where branded drug manufacturers seek to extend their market exclusivity on an expiring patented drug by switching doctors and patients from the old version of the drug to a slightly modified new version. Think Claritin D. The bill would also amend the process for resolving patent infringement claims for biologic products, known as the patent dance. It would also put a reasonable limit on the number of patents that a biologic company can assert in an infringement action to try to block the entry of a biosimilar competitor. Last Congress, this bill was reported unanimously out of the committee. I understand there's a bipartisan manager's amendment. Without objection, that amendment will be adopted. And now let me turn to Senator Cornyn and Blumenthal if they wish to speak on the bill.
Well, thank you, Mr. Chairman, for putting this bipartisan piece of legislation on the markup agenda today. As you point out, it has passed unanimously in the past. Across the country, more people are struggling, as we know, to pay for their prescription drugs and are facing financial decisions that no family should ever have to make. We've had a lot of hearings in the past about these high prices and the tragic consequences, and you mentioned two of them that I think are the most exemplary abuses of our patent system, which I wholeheartedly support, and that is this idea of patent thickets. In the Humira case that you mentioned, Humira is the subject of more than 120 different patents in America. Meanwhile, in Europe, patients have access to 5 different competitors and have had that since 2018, but not in America because of the abuse of the patent system by AbbVie. I'm pleased we have to have the support of your support, Chairman Senator Grassley, Senator Hawley, Senator Klobuchar, and others. And the other abuse is product hopping, which is a practice when a company is about to lose exclusivity on a product, they develop a minor formulation, as you said, Mr. Chairman, then yank the original off the market. Another example is the drug Namenda, which is used by patients with Alzheimer's. Near the end of the exclusivity period, the manufacturer switched from a twice-daily drug to a once-daily drug. That prevented pharmacists from being able to switch patients to the lower-cost generic and gave the company additional years of patent protection. By defining product hopping as an anti-competitive act, the FTC will be able to take action against those who engage in this practice. So there have been a couple of very, what I would call relatively technical changes that are included in the manager's amendment, and I appreciate the support of members of the committee, and I appreciate the good work of Senator Blumenthal from Connecticut on this. I think this will help us make some real progress in bringing down the price of prescription drugs. Indeed, this will actually save money, and that doesn't happen very often around here. Thank you.
Thanks, Senator Cornyn. Senator Blumenthal.
Yeah, thank you, Mr. Chairman. I want to thank Senator Cornyn for his very, very important work on this measure. He and I have worked with other members of the committee on various aspects of the bill to seek consensus. We did achieve it in the last Congress. This committee passed it unanimously. Unfortunately, it never got a vote on the floor, but it really embodies an effort to stop abuses of patents by companies that seek to move their customers from one product to another by engaging in a variety of practices to disadvantage the old drug when they come up with a new one that is in no substantial way an improvement on the old one. And they do it because their market protections are about to expire. They can continue exclusivity, and they keep generics off the market, thereby increasing prices. Senator Cornyn has well summarized, and all of us are aware of the skyrocketing costs of pharmaceutical drugs, and this measure actually will produce enormous savings in the hundreds of millions of dollars, according to CBO. So I urge my colleagues to approve it. I hope the vote will be as substantial as it was during the last time we considered it. Thank you.
Thank you, Senator Blumenthal. Does any other senator seek recognition to speak or to offer an amendment?
Mr. Chairman?
Senator Lee, I noticed first. Who is the other? Senator Ossoff? Senator Coons? Take it away.
Thank you, Mr. Chairman. This bill has a really laudable goal of stopping product hopping. I don't think anyone here will argue that the FTC should not go after those bad actors who abuse our patent system and thereby prevent Americans from gaining access to cheaper drugs. And from what I can tell, the FTC already does have the power to do that. But when attempting to solve a problem like product hopping, we do have to be careful that the pendulum doesn't swing too far in the other direction, stifling innovation and stifling the process of making improvements to existing drugs. My fear is that this bill, as currently drafted, has some potential of doing that, and that's why I've filed 3 amendments to the legislation. First, I'm grateful to the bill's sponsor, Senator Cornyn, for adopting my amendment to narrow the scope of FTC's rulemaking authority. As most of you know, ensuring that we don't recklessly cede our Article I authority to federal agencies is an issue that I care deeply about. I think that's even more important in this instance due to the direction of the FTC under the current administration. My second amendment would ensure that companies that have been taken to court based on a presumption of anti-competitive behavior can justify that behavior by providing evidence, if such evidence exists, that the new product provides, quote, a meaningful improvement in safety or effectiveness, or provides a meaningful benefit to patient care, close quote. That is compared to the listed drug. Much like we don't punish auto manufacturers for updating their vehicles each year to fix glitches or inefficiencies in last year's model, drug companies shouldn't be punished for updating drugs to improve efficacy or safety or other things that are important to consumers. We wouldn't want to chill that lest patient care suffer as a result. This justification would only be available to companies who had produced a new and improved drug while keeping the old listed drug on the market. The bill as currently drafted would only allow manufacturers to rebut the presumption of anti-competitive conduct by proving that they had legitimate pro-competitive reasons apart from the financial effects of reduced competition to improve the new and improved drug. In my view, it's just not quite enough, and I think that it had hurt American consumers by stifling innovation and stifling the process of making improvements to existing drugs. My third and final amendment would tweak the bill's definition of follow-on product, which is the new and improved drug, to ensure that only those new drugs meant to treat an identical or substantially identical condition would qualify as a follow-on product subject to the bill's claims of product hopping. I think my amendments are reasonable, and they're narrowly tailored to help the FTC target the bad actors that use products to delay the introduction of cheaper generics and biosimilars, while also protecting the innovation that patients so desperately need. So I had hoped that we could get each of these amendments worked out before the markup, but we've run out of time. As I did with Senator Klobuchar, Senator Cornyn, I'd be happy to let this one pass out today if you work with me as we approach the floor.
Happy to do so.
Thank you, Senator Lee and Senator Cornyn.
Which one am I offering? I do have one amendment that I want to offer up that I think they're going to take. This is amendment TAM 21F01 as modified. And Senator Cornyn will be offering a modification to that.
Senator Cornyn?
You don't need a second.
Won't be controversial.
He's going to offer a second, and then it'll be accepted.
Mr. Chairman, I would offer a second degree to Senator Lee's amendment. I think this just makes clear that where previously we said that the change in the drug must be for an indication in whole or in part that the previous drug was targeted at, and we've now changed it to say has an indication that is identical or substantially similar. We want to make sure that if somebody comes up with a drug innovation that treats a different condition, that they have the flexibility to do so. We don't want to discourage that kind of innovation, but if it treats the same indication, identical or substantially similar, then that, I think, would be a more clarification of our original intent.
Thanks, Senator Cornyn. Senator Blumenthal, would you like to comment on the Cornyn second-degree amendment to?
Yeah, I support
the
this
amendment?
second-degree amendment, and it represents a compromise among us. And I want to say about Senator Lee's first amendment on rulemaking, I believe we've already heeded the concerns that he's raised in the manager's amendment. On the justification amendment that he's offered, I'm certainly willing to work with him as we continue to the floor on this one. And on the follow-on product amendment, as Senator Cornyn has indicated, I think we've reached an agreement for right now.
So that the chair understands, this Cornyn amendment amends the original bill, does not amend the Lee amendment?
It does amend the Lee amendment.
So it's second-degree amendment?
Correct.
So I'll ask, unless there were two others who sought recognition, Senators Ossoff and Coons, should we go forward? Yeah. So the second-degree amendment to the Lee amendment to this bill S-1435. All those in favor of this second-degree amendment say aye.
Aye.
Those opposed, no. The majority of members present having voted in the affirmative, the ayes have it, and the Lee amendment is amended. The question is now on the adoption of the Lee amendment as amended. All those in, did you want to seek recognition? Absolutely. All right. All those in favor say aye.
Aye. Aye.
Those opposed, no. The majority of the members present having voted in the affirmative, the Lee amendment as amended, the ayes have it, and the bill will be favorably reported to the floor. Are there any further amendments? Does anyone seek recognition to speak before the roll call vote? Senator Ossoff and then Coons.
Thank you, Mr. Chairman. Just want to voice my strong support today for the Affordable Prescriptions for Patients Act. I want to thank the bill's sponsors, commend the spirit of bipartisanship. It's refreshing to see Democrats and Republicans coming together to challenge price gouging and anti-competitive practices and other abusive practices by drug companies and making prescriptions more affordable for our constituents. In Georgia, in every part of the state, constantly, Georgians are out of pocket thousands of dollars per month for prescriptions that are desperately needed to treat illness, to prevent illness. The abuse of American consumers by pharmaceutical companies needs to end. I'm grateful again to all of those who have led this effort in the committee today. And Mr. Chairman, I would ask unanimous consent that I be added as a co-sponsor to S-1425, S-1428, S-1388, and S-1435.
Without objection, two senators are seeking recognition, Senator Coons and Senator Hirono.
Thank you, Chairman Durbin. I'd like to thank and congratulate the co-sponsors of this last bill for working with me in my office. I agree with the general proposition shared across these four bills that we have to do more to make sure that Americans have access to and can afford cutting-edge pharmaceuticals. I've given this bill particular consideration. I do think we need to do more to police bad actors who engage in business practices that negatively impact drug price and availability. But I also am concerned that we continue to protect the patent system itself, this constitutionally created property right that I think is critical to innovation and our competitiveness globally. So overly aggressive use of the tools created in this legislation to sweep up good actors as well as bad actors can have unintended negative consequences. And I look forward to working with the co-sponsors to ensure that we discuss further ways this bill could be improved to avoid unintended negative consequences. Helping consumers, our constituents, get access to innovative healthcare solutions possible because of a strong patent system is my core goal, and I look forward to working with my colleagues to achieve that. Thank you.
Thanks, Senator Coons. Senator Hirono?
Thank you, Mr.
Senator
Chairman.
Cruz.
I'd like to just speak very briefly on Senate Bill 1435. I voted for this bill when it was first voted on last year, I believe it was, but I do share Senator Coons' concern that the patent system is very complicated, patent law is very complicated, and every time we make a change to the patent system or the law, it can lead to unintended consequences. And yes, I share the concern that the effect could be to reduce the incentive for pharmaceutical companies to innovate and invent the next generation of better, safer drugs. So I hope that, I certainly thank the sponsors of this bill, but I hope that they will continue to engage in discussions to make sure that these bills, and this bill in particular, do not have the kind of unintended consequences that I mentioned. Thank you.
Thanks, Senator Hirono. Senator Cruz.
Just very quickly, I'd ask consent to be added as a sponsor to S 1425, to S 1388, and to S 1435.
Without objection. Senator
Mr. Chairman,
Cornyn.
may I just briefly respond? I appreciate the sentiments expressed by Senator Hirono and Senator Coons. I, too, am a strong supporter of our patent system, but I just as strongly oppose abuse of our patent system to the detriment of consumers. That's our goal here, but certainly we look forward to continuing those conversations with Senator Lee, Senator Coons, Senator Hirono, and other colleagues as we move toward passage on the floor. Thank you.
Mr. Chairman, I'm sorry.
Senator Blumenthal and then Senator Booker.
Yeah, I would just second strongly the sentiment expressed by Senator Cornyn. We need a patent system. It should be a strong patent system. It has to be enforced rigorously. We need to give the enforcers the tools to prevent abuses. And what we've seen, all of you know it, is that generics have been kept off the market. Innovation has been stifled because of the abuses in the patent system's enforcement and the exploitation of some of the loopholes. And what we're trying to do here is essentially make the patent system stronger by validating new products, innovation, and generics so they can come to the market and reduce the cost of pharmaceutical prices. So I just want to say that we've worked on this in a very bipartisan way. I want to thank again Senator Cornyn for his leadership and others who have worked with us very constructively, and I look forward to continuing our work with Senator Lee and others who have constructive suggestions.
Thank you, Senator. Senator Booker.
Thank you, Mr. Chairman. As with 1425, 1428, 1388, I'd like to add myself as a co-sponsor to 1435 as well.
Without objection.
Thank you very much, sir.
If there are no further amendments to come before us on this bill 1435, I would ask for a voice vote on 1435 as amended. All those in favor say aye.
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 Those opposed, no. Majority of members present having voted in the affirmative, the ayes have it. The bill will be favorably reported to the floor. With the floor vote we took late last night and with the activity this morning, there seems to be a breakout of bipartisanship in the Senate, which I think is a healthy thing. With that, the meeting is adjourned.
Been some bipartisanship. However, there's also been some conduct in this committee that has me concerned. And in particular, we have discussed before in meetings of this committee the majority's willingness to disregard committee rules to try to force through the confirmation of nominations. This week, we didn't see a violation of committee rules, but we did see the principles of comity and the norms of this committee disrespected. And in particular, I want to focus on the confirmation hearing for Toby Heitens, who is a nominee to be a judge on the Fourth Circuit Court of Appeals. As the chairman knows, every member of this committee is on multiple committees, and multiple committees often have multiple hearings scheduled simultaneously. And so any senator to do his or her job has to go from one committee to another committee and schedule your time accordingly. And the way the Senate operates is that whenever anyone is chairing a committee, there is some understanding for the logistical challenges of being in multiple places at once. And the chairman of a committee typically accords the respect and courtesy of communicating with the members on that committee and allowing reasonable time for committee members to arrive. This week's hearings on Toby Heitens allowed a total of 18 minutes questioning for a Court of Appeals judge. 18 minutes. Mr. Heitens was there at the beginning of the hearing. Senator Blumenthal, Senator Durbin, Senator Coons, Senator Hirono, Senator Booker, Senator Grassley, and Senator Kennedy were all there. There were introductory speeches, and when it got time to questioning, a couple of things happened. Number one, 3 of the Democratic senators who were here, for whatever reason, made the choice not to question, and so Senator Coons, Senator Hirono, and Senator Booker did not question. Senator Blumenthal was chairing that hearing. There was one Republican who questioned, Senator Kennedy. Now, my staff informed Senator Blumenthal's staff that I was on my way here. Senator Hawley's staff informed Senator Blumenthal's staff that he was on his way here. We were both walking to the hearing. We were on the elevator. And yet, knowing that we were on our way here, and Senator Lee also informed Senator Blumenthal's staff that he intended to come and ask questions as well. But instead of waiting what would have been 30 seconds for Senator Hawley and me to walk into this hearing, Senator Blumenthal took the opportunity, looking around and seeing no Republicans in the room for that instant, to gavel down and send the Court of Appeals nominee on his way. That does not honor the tradition of this committee. A Court of Appeals nominee deserves more scrutiny. And I would note, Mr. Heitens has troubling aspects of his record. Had he been here, I would have asked about his defending COVID laws that discriminate against people of faith. I would have asked about his leading an amicus brief to the U.S. Supreme Court arguing that the government has a right to tell Catholic schools who they have to employ to teach children about the Catholic faith. I get why the Democratic majority doesn't want those questions. Those questions are inconvenient. When the president is nominating radicals who will undermine religious liberty, that's not a good look for the voters to hear. I also would have asked Mr. Heitens about why it is that he seems to view himself as part of the legal, quote, resistance to President Trump, because he voluntarily sat on a panel and spoke on a panel entitled The Legal Resistance to the Trump Administration. And I think it should trouble all of us if we have federal appellate judges who view themselves as part of the resistance. That doesn't exactly express judicial temperament. The gavel in this committee has varied from Republican to Democrat. It's gone back and forth. It will vary again. And part of what makes this committee operate is having the simple courtesy that if a senator is on their way, all of us have had an instance. Every one of us has sat there, and if a senator is coming, well, I'm informed that I'll use hypothetically Senator Klobuchar's on her way, so we'll just filibuster for a minute or two till she gets here. And that's how this place operates. 18 minutes isn't enough for a Court of Appeals judge. Josh and I were both on the elevator headed up here when the gavel came down. That is not going to encourage this committee operating properly. I would suggest that Mr. Heitens deserves a real hearing where senators can actually question his record, not simply a hearing in the dark of night where he's rushed out because of scheduling conflicts.
Senator Cruz, I've worked to ensure that members on both sides of the aisle are treated fairly and have an opportunity to question witnesses at hearings and speak their mind at markups. I hope that was evident this morning and has been evident before. But if there are no members present to ask questions at a hearing, we have to move, and we had a panel of witnesses that was there for the hearing as well. and concluding the hearing. There may have been a miscommunication in this situation. We are all extremely busy, and many times not only the regular order of business, but floor votes are taking place at the same time. At the start of yesterday's nominations hearing, my staff advised staff on both sides of the aisle that given the 11:30 vote that we faced, we needed to get through 2 panels. We would proceed immediately to the second panel if there are no members present to question Mr. Heitens. Again, there may have been a miscommunication at staff level or otherwise, but I don't think there was any malicious intent by Senator Blumenthal. I thought did an extraordinary job at that hearing, and I recognize him.
Thank you, Mr. Chairman. I regret if there was a miscommunication, but I would remind members that we did face 2 votes. We had another panel, and we were not told when other members might be arriving, and many of us have encountered the same situation where we've been on our way, but the committee has had to move on. So I think the questioning of Solicitor General Heitens was very full, and there were members on both sides of the aisle that were there at the beginning and left and did not return before he finished his testimony.
Senator Kennedy, then Senator Coons.
I'm just confused. Did Senator Cruz's staff contact Senator Blumenthal's staff?
I don't know, Senator.
I missed the question.
Did Senator Cruz's staff contact your staff and say, we're on our way?
We were told that various members were on their way.
And was it indicated how long?
On both sides of the aisle, there were other members.
I get it. I mean, I know, we're all busy. But did they indicate how long it would take for them to get here?
Not to my knowledge.
I was there, and I frankly was a little surprised we didn't have more senators there for an appellate. I don't share Senator Cruz's perspective on the nominee, but that's not the issue here. I just think we ought to accommodate everybody's schedule as best we can. You know, you can win or lose a vote. That's why, you know, God made votes, but everybody ought to have a chance to question an appellate court nominee.
Senator Coons?
Could we bring him back, Mr. Chairman?
I really don't know the answer to that.
Aren't there questions for the record still?
Of course.
No.
Senator Coons?
I was simply going to raise the point.
Mr. Chairman, aren't we adjourned?
No.
I was simply going to raise the point, having chaired many such hearings, first, that it is at times difficult to manage 2 panels. But I respect the point raised by my colleague from Texas that we need to be attentive, particularly when we know members are going back and forth between several committees. It is difficult to step in and to chair a confirmation hearing and to manage it all with staff. But there are questions for the record available. I know that's not the same as an in-person question. I recognize this is a lifetime appointment to a circuit court, and so is significant. And I appreciate my colleagues raising the issue, and I hope the chair will work together with all members to ensure that we're balancing the competing demands of floor votes, panels, and timing in a way that allows all members to question.
Anyone wish to speak? If not, the committee stands adjourned.